With you, my lords, that it is actually good democratic practice to subject judicial decisions to heightened scrutiny. It is good practice. It grows judicial accountability. And therefore, what the Senate did by approving this ground was a clawback on an important democratic practice of enhancing judicial accountability. The two grounds that I want to do simultaneously are grounds 5 and 6, because they suffer the same fate of inadequacy. Grounds 5 and 6. Ground 5, and both of them were approved. So I've already dealt with one that was approved. I'm dealing with two others. Then I'll deal with two others to finish the 5 that were approved. Ground 5 accused the Deputy President of gross violation of Articles 3.1 and 148.5a of the Constitution and fidelity to the oath of office and allegiance. Then ground 6 provided that the Deputy President, that there were serious reasons to believe that the Deputy President had committed a crime under sections 13(1)A and 62 of the National Cohesion and Integration Act. Those were the two grounds. So, a ground must be supported by particulars. That's what the Supreme Court has said. Then the particulars must be substantiated. Now, when you look at the motion, ground 5 had no particulars of its own. Ground 6 had no particulars of its own. Instead, what the drafter of this motion, in his drafting wisdom, did was to say the grounds in support of ground 5, the particulars in support of ground 5 are the particulars in grounds 1, 2, 3, and 4. That's what he said. Similarly, in respect of ground 6, the drafter didn't supply particulars. Instead, he said the particulars in support of ground 6 are the grounds set out in the particulars set out in grounds 1, 2, 3, and 4. My lords, as experienced jurists, you know better than I do that particulars are the specific acts or omissions constituting the wrongdoing. The specific acts or omissions constituting the wrongdoing. The National Assembly went to the Senate and said, we are charging the Deputy President in ground 5 and ground 6 because of the acts and omissions we have referred to in grounds 1, 2, 3, and 4. Is that a permissible way of framing a charge of impeachment? I began by setting out that it has been established that the grounds, the charges in impeachment are framed in the same manner as charges in a criminal case. This court, the High Court rather, has held in 3 different cases. The case of BMK versus Republic, 2020 EKLR. The case of LKO versus Republic, 2022 EKLR. And the case of Etiang versus Republic, 2022 EKLR. I'll just refer to one because they make the same principle. Justice Ongudi said, and I quote, "The problem I find in the charge sheet is one of multiplicity of charges. Then she defines multiplicity. Multiplicity in a charge sheet arises from charging of a single criminal act as multiple separate counts. This may result in violation of the right of an accused person under Article 50, Clause 2, Paragraph O of the Constitution. That multiplicity of charges is a violation or a threat to Article 50, Clause 2, Paragraph O. And it defines multiplicity to mean charging a single act as multiple separate counts. So therefore, when the National Assembly tells us that the acts in ground 1, 2, 3, 4 are the same acts that constitute the ground 5 and ground 6, these two grounds were bad for multiplicity. They were a violation of Article 50 of the Constitution. They cannot found a threshold for impeachment. Both of the two grounds were approved by the Senate as constituting the basis for removal of the Deputy President from office. But there's something very bad about it. The Senate voted to approve grounds 5 and 6 on the particular set out in 1, 2, 3, and 4, and ground 5 on the particular set out in grounds 1, 2, 3, and 4, but acquitted the Deputy President of grounds 2 and 3. And remember, they gave no reasons for convicting. And that's how obscene this trial in plenary is, as my learned colleague, Mr. Chell Dudley, will take you through in a short while. Then finally, ground 1. Ground 1 accused the Deputy President of gross violation of Articles 10(2)(a), B, and C, 73(1)(a) and 2B, 75(1) and C, so 75(1)(c) and 129(2) of the Constitution, and Articles 47(1) as read together with Articles 131(2)(c) and D of the Constitution. In summary, my lords, these were the grounds that accused the Deputy President of talking about shares in government and shareholding in government. Let me just paraphrase it like that. That's in summary what this is about. My learned colleague, Mr. Tom Masharia, took the motion mover through cross-examination on this ground. You will find that at pages 88 to 94 of the Hansard of 16th October 2024. So a number of things emerged. I just summarize them. Number one, the motion mover confirmed that the government of the day in Kenya is formed by a coalition of parties named the Kenya Kwanza Coalition. Motion mover confirmed that as a fact. Number two, he confirmed that the Kenya Kwanza Coalition was formed of pre-election coalition agreements involving various parties. Number three, among the parties were UDA, ANC, Ford Kenya, and PAA or PA, as is sometimes called. And my Lord, this must come out very succinctly from me. It bears that PA is the party whose party leader was the Speaker of the Senate presiding over these proceedings. When you finally take time to read pages 88 to 94, the motion mover confirmed that each of these coalition agreements made references to sharing of government. And they expressly spoke about sharing government positions and sharing resources. You'll see the coalition agreement between Ford Kenya and ANC talking about certain roads in Western Kenya, nowhere else. You'll see the coalition agreement with the PA talking about development of marine resources in coastal Kenya. You will see positions, the leader of Ford Kenya being promised the position of the Speaker of the National Assembly and certain cabinet portfolios and principal secretary portfolios. The leader of the party called PA being promised a position of the Speaker of the Senate. The question, therefore, is that when parties enter coalition agreements and pre-election manifestos, it is the people who determine whether they want to be associated with that kind of manifesto or that kind of pre-election arrangement at an election. For some reason, the people of Kenya chose this agreement with shareholding arrangements in 2022. If the people of Kenya are unhappy, they have another opportunity in 2027 to deal with it. And that is exactly what the High Court set out in the Sonko decision that I have just referred to. If you look at the High Court Sonko decision at paragraph 258, the High Court says an impeachment is an important remedy, but one of last resort. It is one to be used where there is an injury to the people. The remedy should be limited to only the gravest political wrongs. This is because the person to be removed came to office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle.